Brian Parker here. This is very unusual. I'm sitting in my car. It's about 30 degrees in Detroit, and I wanted to do this video because it's in my head. This is appeals week for me. I'm up in Detroit for the first time. I go back and forth, but I'm here for a whole week. And it just so happens that Wednesday is a huge storm coming, first of their winter season. And I'm supposed to leave Friday, but I have a hearing on Thursday. It's a circuit court of appeal for a lower court that I'm appealing. Last Thursday, I had a district court case and I won it in circuit court. District court is anything under 25,000, which is where most collection cases are. I didn't like how they ruled against me, so I appealed it. And in like a slugfest with your old buddy, Bradley Johnson, I say that if you can just see one of the videos that I did um, deposing a collection attorney. It was him. And he is since no longer working with the plaintiff who was appealing. The judge made them bring him back to argue, even though he doesn't work for that firm anymore. The actual owner of the law firm showed up. And so he was there for the third hearing for this appeal. And it went great. I don't know why the judge wanted him back. He's actually wearing a suit, Mr. Johnson. And the judge went our way. We overturned a velocity case that was exactly like the case I'm literally minutes away from arguing. But this one is before the Michigan Court of Appeals. So you have district court, circuit court, which takes cases or appeals from district. Circuit court only handles cases $25,000 or more or equity. And then if you don't like circuit court, you go to the Court of Appeals, and then it's the Supreme Court. So I'm in front of the Court of Appeals today, and I thought I'd do a video on how to do that. With this video will be my actual brief, their response, my reply. I'll throw in some Word documents if you really want it. Um, I'm going to give you with this video notes on how I prepare or how you can prepare. As I wrote it, I literally was writing it at the appeal. I felt so good about the appeal. Having just argued for hours against Velocity and fortunately winning in a circuit court just last week, it was practice for me. Now I'm here at the big boy at the Michigan Court of Appeals, and in I go. But that preparation for something that big starts 2 years ago when they filed the lawsuit against my client and the counter affidavit which accompanies your answer. In the appeal, I made that part of my retention and my study and my preparedness. That Court of Appeal that counter affidavit is very valuable, even in the Court of Appeals. So I jotted down some notes. I'm driving to Detroit. There's a storm coming. They make a big deal out of it. I haven't been driving in Detroit that much. It's full of billboards for attorneys, injury attorney. And then I noticed I'm located in the suburbs. It's all hospitals and mortgage companies. But as soon as you get down to downtown, whatever your vision of downtown Detroit is, it's still that. It's just surrounded by large corporation buildings and the roads are really nice. But it's all injury billboards everywhere you go. Just three attorneys have manipulated all of the billboards. So whatever, we're right at the brunt of the storm, and I feel like I'm heading for a storm, but I feel very prepared. I was ready last week, but you have to condition your brain going into the motion that is in front of you. So I have one on Thursday at the circuit court. So I lost it in district. I know I was right. It goes to circuit for the appeal. And if I don't win that, I'm going to go to Court of Appeals. That's how strongly I feel. I don't do it unless I feel really strongly. And I know, and that's an LVNV funding case, but it's all the same. It's bad title. And today I was presenting the court with all the reams of information that I have that's in my head that's written down that I'm going to attach this to the video. And you want to see what I took in? That's it. Why? Because you can't bring in this big folder. I see attorneys with a huge folder and this That's insecurity. If you don't know your case well enough, then get the hell out of the way. That's it right there. That's the whole Michigan Court of Appeals presentation I made. It's the same. That reflects my counter affidavit I made on February of 2023 when this case started. The only thing I allowed myself was some deposition testimony that's something that wasn't always there. I deposed their main witness that represent Velocity. And so I wrote down all the mistakes that their witness, who was in charge of Velocities, their attorney in charge of compliance. And I started quoting because I had it right there, but it was really right there. And so it's a panel. When you're in front of the Court of Appeals, it's a panel of 3 attorneys and they're judges, and they've ascended to high up. They're one step away from the Supreme Court. And so it's kind of, I've done it before. It was, I think, perhaps the same room I'd done it before. So I just recognized as I was going along. But when I'm really ready, when you're really ready, I float. I barely touch the ground. I feel as though I already feel good and I've even gotten to where I'm at. So my point telling you that it's attitude, man. I sat and the guy that was running things. Now, by the way, I got there an hour early, so I watched who was running, who did all the talking. So when I got up to the podium, and by the way, I was so confident. I sat there waiting to be called. So did Sister Counsel. They called me up, and I was just doodling. I was that feeling good about it. They had to bring to my attention, hello, counsel. So then I'm like, oh, I got up and it was just it sometimes, man, and that's preparation. I was on, and the main judge who was asking all the questions, I locked eyes, and it was like, if you will, a beautiful girl, and she's into me and I'm into him. Sorry. I'm not beginning politics here. And he asked the questions I'd already prepared for because I prepared, but I'd argued the case last Thursday, but you still don't take anything for granted. So I argued this case in my apartment, in my kid's apartment where I'm staying, in my sleep last night. So I was ready. I was nervous and sleep deprived, but I was ready. But his questions I had the answer. And what I did is I made it personal. When he asked me a question, he kept quoting from the deposition I took. And I said, Your Honor, did you just study the deposition and nothing else? And he started laughing. I made a connection. The other 2 judges of the Court of Appeals said nothing. They let him go. And we kicked it. He got the fact that there was no title change or assignment from the original creditor, in this case, Cross River Bank, to their weird trust. In this case, it was MPL Capital Holding. And then 6 months later, Cross River is sending it to sending it to Upstart Network. You know my Velocity videos. There's thousands of these uh, Velocity cases out there where the bad chain of title. He got it. The one on Thursday I did previously, it took me probably 3 hours, literally, to get the judge to where this judge I'm in front of the Court of Appeals got it like that. And I'll tell you why that is. Because unfortunately, at the very district court letter under 25,000, they're dealing with landlord tenant collection cases. He said, she said, hey, he's going over my fence. All these kind of meat and potato cases, they've got thousands of them. But if you've got a summary motion, please, judge, take the time to read it. They still don't. You get to circuit court, you get the right judge in circuit court, they will read it like a Court of Appeals judge, and they may be thinking, I want to be a Court of Appeals judge. So that's good. But even at circuit court level, the case I was in front of today, I presented at circuit court level everything, the kitchen sink, and it was clear I'd won the summary motion. The judge literally said to my opponent, hey, that thing he's got about the chain of title, you got the chain of title, right? And she says, yeah, of course. I've got all this paperwork. She goes, okay, I'm convinced. It was that obvious. And I put that in my brief to the Court of Appeals saying, see any work being done that you're hopefully going to do? I know they're going to do the work. And I quoted her going, well, looks good to me, without having any benefit of actually reading the file. But the Court of Appeals, they're reading the file. And this judge, he had read everything. He had several other cases. And I was in the elevator afterwards, and an old time attorney goes, yeah, I know those judges, kid. And I'm not a kid, but he's old. He goes, I hang out with them, and they tell you all the time, it's all about the briefs, not about the oral argument. But what the oral argument did, it confirmed to me, I believe, and I don't want to jinx myself, that they believe my case and my client. So the other side, first they attack me, then they attack my client for not paying his debts. So I knew that was coming. So after I made my short argument, I go, and I remember advocacy is not evidence. Lack of payment has nothing to do with ownership. So when her questions came in, they're hearing what I already set them up for, which I think they felt that way anyway, but they have to make a good faith effort to kind of challenge me. Now, when she got up, this particular attorney, I still scratch my head. I go, why is anybody even listening to this? At every level I see her. At this level, you're at a level where you better bring it and know it. And they went in on her. And every time they got to a point where she didn't like what they were asking her, because she clearly knew that they did not have, that Velocity did not have the chain of title. And I'm going to tell you what she said every time. Well, Your Honor, it's the collector nature of everything. I'm not sidetracking what you're asking. They were asking, where's the assignment Mr. Parker's saying is missing? She kept saying the collective nature of everything. And I told the court down in the circuit, she said, Your Honor, there was so much paperwork, it was hard to keep up. But the judge down there read it all. So that decision against Mr. Parker should stand. So I got up and said, well, if there was that much paperwork, why not just direct the court with an affidavit saying, here's why we own the debt? Because, Your Honor, as they know, it's been 2 years of them not producing the things that are missing, the title showing my client's debt jumping to Velocity, which there isn't. Wouldn't you have got an affidavit by now? Your Honors, do you have that affidavit in front of you? We don't. That's right. Do you have the assignment in front of you showing that they own the debt? There's nothing here. And their questions to me were trying to help her out, saying, well, isn't it just inferred, which is a BS question, but they weren't being rude. I said, yeah. So if you had a house and there were 2 missing assignments, what title company is going to insure that? And that resonated. If you owned a car and there's 2 missing buyers from the chain of title, you're not going to the Secretary of State to get that registered, or you can't even sell it. And that resonated. It's the absence of a chain of title that makes me ask them for what you ask for. Your Honors, there's clearly a breach here in that there is no issue as to ownership. There's a genuine issue of dispute with ownership. That's the bellwether or the standard you go into. You got to show that there's a genuine material issue. So you better know that from day one and cite that and show that with your counter affidavit. But I'm giving you a few tips today. I'm going to add in a second all the tips to go do an appeal. As I wrote them, I thought, wow, why isn't this any good at any level? And they are. So I'll give you a real quick. I wrote all this in the hearing, by the way. So I'm just going to give you my schlop here. Have one single sheet to argue from, because you should have knowledge of this whole thing. I'm not saying that you have to have the greatest. I just haven't, look at me. I'm not handsome, but I have good memory. So I know my good, and I'm certainly know my weaknesses. But I don't have a good memory if I can't get it in that brain. And sometimes I got to do it 64 times. But if you ask me right now, I'll tell you everything and the dates and everything. But I know my weaknesses, so I got it down. You've got to keep it simple, stupid. Hit it and move on. That's how you take the bar. You only have 3 or 4 seconds to answer a question on a bar. You better hit it and move on, right or wrong, because you're going to kill your other chances. So I had to hit it and move on, one sheet. And here's what you need. Here's my tips. Have one sheet have your appellees brief, and find out where they missed the boat. So go read their brief and find out where they're saying things that aren't true. In my case, there was clear things that weren't true, and they were changing names to fit into this pretzel litigation that is debt buying in a securitized world. So I had that down. I had that in my brief. Come up with a catchy phrase. The most famous one is, if it doesn't fit, you must acquit. Well, I remember that because we all remember that, because it's have that catchphrase be what you want them to remember. So mine was a missing link goes down the sink, and I have two absences here. There's no link between the original creditor and the trust, and there's no link between the eventual and current owner of Upstart Network Inc. and the person suing my client. A missing link goes down the sink, and it kind of speaks to something's missing, and their case is going down the sink. So it's kind of silly, but whatever. So line up your arguments, killing theirs. Assume that they're going to come a certain way and already have those arguments. So the judges actually used my arguments against her. And she got frustrated. So she said this, in a sense, she said, just trust me. It's the custom of the trade that we do things like this without the assignments. I'm going to download when I get the transcript. So the judge went in and said, custom of the trade. Was that the custom of trade in this case? Is that why you don't have the title? And she evaded by first saying, well, I'm not going to evade this. And then she just evaded. Usually when people say stuff, they go, well, I'm not da 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 da. They are. Like you hear a friend who constantly bother you, go, look, I don't mean to be a pest. They are being a pest. They're recognizing that they're being a pest. That works in law too. I'm not going to be evasive. Well, if you're not going to be, you don't need to say that. Who are you convincing? The people you're talking to or yourself? And she was clearly evasive. You can't be evasive. You are being checked and you're making a good first impression. I came in smiling. I made eye contact. Here's a funny story. This actually happened. Before the judges take the bench, the court clerk that sits there and the bailiff watching over things said, he stood up. He said, I just want to give you something I heard today. I don't want to hear out of your mouths. Now, I don't have to listen to that guy, but I'm going to show him deference. He's got a job. He's got to watch things, and he's actually helping you out. He said, this is what he said. There was an attorney before you guys, and he said, you guys came in, and he referred to the court as you guys. He kept referring to the judges as you guys. He says, and so the guy said, I don't want to hear this from you, gentlemen and ladies, today. Don't refer to judges of this high order as you guys. So I thought that was kind of a TikTok world type of thing. You see that in TikToks all the time where people go, hey, you guys, you can't do that at the Court of Appeals, okay? It's going to get noticed. And that's the important thing of a Court of Appeals. It's by the book, baby. You can't fake it in the Court of Appeals. You have to. And one of my tips is go to a room and pretend you're already in the hearing and see the judges and have them ask you questions and answer those questions. Come up with the most absurd stuff. Have an answer to every possible question. You'll get that from the appellee's brief. That's the person that you're the appellant. The person responding to you is the appellee. So have an answer ready. As far as the judges, because it's so serious in the Court of Appeals, do a deep dive. Find out their likes and dislikes. Find out, are they defendant-oriented or plaintiff-oriented? Are they former prosecutors or are they former public defenders? In my line of work, I want the public defender. But I got to tell you, to break it down as Democrat or Republican does you no service. I don't like politics here because Republicans are fine to be in front of from my standpoint, even though they're pro-business, and my client's obviously anti-business in some respect, but they will follow the law. And the main middle guy was from a county called Kent County in Michigan. That's a Republican area. And he asked those type of questions. And he and I kicked it because we both believe in the rule of law. I believe in the rule of law. And he understood my answers and he was smiling and laughing with me. We had a good time. I don't know if that's good or bad, but we connected. And that can go bad for you if you don't connect. I'm telling you, regardless of how hard it is, eye contact matters. Answering questions and looking someone in the eye matters at this level. Don't look down. If you have the letter C because you're always on your phone and you don't like to look up and your back's a letter C, you'll see those people. Should not do appeal work. If you go on your phone all the time and don't do the hard work, do not do appeal work. I am not judging you. I can see who is and who isn't good or bad at something. I'm pretty good at what I do. I look for people better than me to better myself. I always have, and I have work to do, but I also know bad. We all do. You go, oh my goodness. And I felt that way about my opponent all the way up, but judges were giving her a break with the, ah, shucks. It's the cavalcade of paperwork, Your Honor. You don't need to read it. At this level, you need to read it and know it. And she failed miserably. So find an opinion of any judge you want to impress. I've actually at the Court of Appeals of Federal, right underneath the Supreme Court, the U.S. Supreme Court, I found an opinion of a judge where he loved the gray wolf and he quoted from poems of the gray wolf. So I somehow got that into my argument. Is it going to help? That opinion, by the way, though it went against me, is often quoted on both sides of the V, of both appellants and appellees, plaintiffs and defendants quote that opinion that was produced in my case because it works for both sides. Even though I lost, I quoted a guy's favorite poetry because I found it online on that person. So I know something about everyone and I try to get it in without being obvious. Well, the gray wolf would say, I wouldn't say that, but I would say, the hunger of a gray wolf makes it do some strange things. So I've keyed into him. The other two judges, what the hell is he talking about? But then I'm going to give them a little morsel. It's about just connecting. Connect. Now, if you believe you can't win at oral argument, all right. But what if you're tipping on the balance? It's 51 to 49 when these guys get together, decide which way they're going to go. Hey, I like that guy. He knew about the gray walls. Blah, blah, blah. Whatever it takes, inch by inch, anything's a cinch. But you got to break it down. If you get hit, move on. Hit it and move on. When you go to a hearing, get there early. I was there an hour early. It gave me a chance to get comfortable, review in my car for any deficits I thought I had. But actually, I just sat back and watched how people argue and how the court interacts with those people. I go, I know the main guy now. And that's what I did. And I'm going to tell you I did this. If the judge cracked a joke and she was looking my way, I laughed. I need to connect. You need to connect. Let's say you don't want to connect. You better make sure you got the best case in the world. You don't. But that connection, every honest and long-term relation is based upon connections. Every successful relationship is based upon connections, communication and connection. And so connections won't hurt you. So connect. Remember what I said about knowing the other side's case? I knew they sucked. Their case sucked and they were getting away with BS. But at this level, you're not going to get away with that. And the court called them out on it right at the beginning. She said, Your Honor, he hasn't risen to the level of a factual issue. And the judges cut her off and said, but this isn't that. At the appeal level, it's a de novo analysis. A de novo analysis is as though the case has never been litigated before, and you're giving the panel, they are the new judges, as though the case had never appeared in front of her anymore. And that doesn't require some high burden. Her whole brief and argument was based upon a higher burden than was not even applied. So she was kicked in the butt for her lack of attention to the good stuff and the things that matter. And they just didn't stop derailing her. So she was just left at the end just going, it's the custom of trade not to have this. or it's the cavalcade of evidence. There's so much evidence here. Why do I have to actually give you evidence? That was their side. It's kind of embarrassing. Right or wrong, I'm going unprepared. I'm going to give you a tips list with this video. I'm on a high right now. I'm high as a kite from adrenaline and whatever else. Because leading up to this or any court event, I was throwing up. I was having trouble brushing my teeth. I was choking. I was choking wherever I went, coughing, trying to keep everything down up to that event. So finally you get it out. The preparation is key. Knowing their case is key. Knowing your case, sitting in a room with no radio, nothing, and going, I am now sitting before the panel. He's asking me this. She's asking me that. They're asking me this. And I'm having answers to everything. That confidence alone is enough. So you get 15 minutes. You get half an hour. Your other side gets 15 minutes to rebut, I believe. No, 20 to present, 20 to rebut. Then you get 15 minutes to rebut whatever she said. 10 minutes I took. She went on, and then they started kind of shutting her down. Then I took maybe 5 minutes as a rebuttal. I felt that good. You can feel good about the case you're in front of or the case at the Court of Appeals. Just do the work. It pays off. It takes away nervousness. This was an interesting video, I know. I'm going to add stuff for you, appeal briefs, a list of everything, how I would like you to type a synopsis for one sheet, not just for your Court of Appeals argument or your appeal, but for your pretrial. It matters that you know. And if you know something better than the other side, judges notice, even at the district court level. So don't miss an opportunity to connect and make a great impression. I hope this video, while meandering and on and on and on, because I'm so high right now, is helpful. If not, the tips will be, the paperwork will be attached to this. Like, love, and subscribe, and leave any comments that you want. Thank you very much. Thank you for your attention. Bye.